Should employers be concerned about their employees' blogging activity? Hi, I'm Norm McInnes, and I'm talking to Stuart Rudner of Miller Thompson, LLP, who practices commercial litigation with a particular emphasis on employment law. Stuart, what exactly is a blog, and what is blogging?
Blog, to my understanding, is a short form for weblog, and the simplest way I can put it is that it would be an online journal or diary where someone, as opposed to a traditional website, someone is updating the content on a regular basis, either daily or weekly or monthly perhaps, and there are blogs covering everything from someone's social life to covering someone's favorite sports team. And in fact, some companies have started to use blogs as a method of marketing where they can keep people up to date on what's happening at the company, new products, etc. And blogging is simply the act of having and maintaining a blog.
So it's an online journal that's pretty well open to anyone who has access to the Internet.
It's a very cheap and easy way for someone to get their thoughts out to potentially millions of people.
Now, why should employers be concerned about their employees' blogs?
Well, following up on that last comment, there's an audience of potentially millions of people, and the real concerns are employees who might divulge confidential information, products that are in development, or financial information of the company. There's also concerns that employees might post information that will embarrass the company or in some way harm the reputation of the company, and there have been examples of both of those already. The best-known Canadian example was a person named Matthew Brown, who was an employee of Starbucks and was upset at his boss who wouldn't give him a day off because he was sick, and complained about his boss on his blog. According to Matthew Brown, he never thought that anybody but his family and friends would see this, but it very quickly came to the attention of Starbucks, and he was actually dismissed on the very day that he was supposed to start his management training at Starbucks.
Okay.
Another good example happened with Google, where a relatively new employee published comments on his blog about the financial conditions at Google, which obviously was of great concern to them, and he also lost his job very quickly.
Mm-hmm. I suppose there's also a possibility of commenting about fellow employees, and there's the kind of conversation that would normally take place around the water cooler, but about new hires and about people being fired or whatever, and so those sorts of things could also be thereby put into the public domain or embarrass the employer.
Well, that's just it. I mean, in the past, those comments would have been made around the water cooler or at the pub at the end of the day, and maybe a few people would have heard them, and no one would remember exactly what was said, and there would be no record of it. Whereas in the case of a blog, as I mentioned earlier, I mean, there's potentially millions of people who see these comments. They're virtually impossible to delete once they're posted on the Internet, and there is a precise record of exactly what was said.
And even information that might be useful to a competitor. I've heard it suggested that even a mention that you, the employer, in a particular city may be enough information for a competitor to surmise that what is happening, what is going on.
Oh, it's very easy for people to do that both ways. I mean, first of all, for a competitor to determine what company is being discussed, but also for employers who are concerned about blogs that refer to their business. It's not unknown for employers to track down who's posting blogs just based upon a city or a photograph in some cases and take action against them.
Now, I guess there's also a possibility of an employee posting harmful content, defamatory statements or obscene or offensive comments of one kind or the other. Can an employer be liable in certain circumstances for defamatory statements or held responsible for offensive material?
It depends on the context, and here is where I guess you have to distinguish between activity that is taking place while at work as opposed to off-duty conduct. It's conceivable that an employer could be liable for that type of activity if it's being done using the company computer on company time, and if there is any reason to suggest that the company is aware of it. I mean, otherwise they're generally not going to be held responsible where someone is doing things that are clearly beyond the scope of their employment. But then you get into the interesting area, which is off-duty conduct. And typically, once an employee is off-duty, they are not subject to discipline for their actions. But that is not an absolute. And in the case of blogging, if the blog content does anything that, for example, damages the company reputation or impacts upon their ability to compete or impacts upon their ability to manage the workforce, i.e., posting comments about supervisors, colleagues, management, etc. Those are all the types of behavior that can lead to discipline, even if it's done when the employee is not at work.
And then I guess there are also privacy concerns that, again, because as you said earlier, this is so instantly published and so accessible to everybody that personal information about clients or customers of the employer might inadvertently get published in a blog.
Yeah, that's just one more example of why companies should be concerned, and one more example of how they or why they need to control this type of activity. That's why when I am providing advice to clients, my recommendation is that this is just like any other activity of concern, whether it's internet use or email use or anything else. You have to make the rules clear so that all employees and all management know what is allowed and what is not allowed. And the best way to do it is to have policies in place that make it clear you can't post proprietary or confidential information. You can't post information about customers or clients or suppliers. You can't make comments about your colleagues, your supervisors, or management, or just have a very general clause either in an employment agreement or in a policy that says you will not make disparaging remarks about the company or its employees. And that would apply to blogs or any other context.
I guess in this case, as in so many others, an ounce of prevention is worth a pound of cure. So
that's exactly right.
Have a policy up front and make the rules clear beforehand, and that could prevent a lot of harm in the long run.
Yeah, like almost any other context in the employment law world, laying out the ground rules is fundamental to being able to enforce them.